on that to comment on what his personal beliefs are with regard to that. And also would be outside of the scope of voir dire and serve no purpose for the voir dire proceedings.
Okay, thank you, Ms. Blake. Two different motions there. Mr. Pryor, if you'd like to respond first to the state's objection, you're referring to the four prosecutors. Sorry,
Judge, if you have some suggested language for me in terms of how it's supposed to refer to them, I'll be glad to take that language, because I don't see the prejudice referring to four prosecutors on the other side of the table. If the court feels that's prejudicial, then you know, if you want to tell me exactly how I'm supposed to refer to those folks, I'll be glad to do that. But I see that's a little. I feel like the prosecutor's picking on an issue. They feel there's prejudice there. Then the judge instruct me how you want me to address those folks. And, as far as the other issue is concerned, Judge, I'll temper my response and ensure that I advise them in a less than definitive manner in terms of the other issue.
all right. Well, in terms of the first motion, I'm not going to prohibit some mention or reference to four prosecutors. That's who's at the table. The jurors are going to see that anyway. If it is being referred to unnecessarily or in a way that's irrelevant to procedures or selecting jurors in the voir dire process, then the court will consider that under advisement, but I'm not going to prohibit a reference to what they're already seeing. It was said, it was repeatedly made, perhaps in a way to try to garner sympathy. It looks like it's rising to that level. I'll reconsider it. You may either raise the objection, Ms. Blake, or I may speak up and advise counsel that we would consider that to refrain from that reference. But in general terms, it's not going to be prohibited. In terms of the statement that was probably what would be framed as vouching, then Mr. Pryor would be correct that that's an improper kind of statement to vouch for your client personally or make a unqualified statement such as that. You've indicated you'll refrain from that, so the state would grant the objection on that and instruct that there not be further references where you are vouching for the innocence of your client. So that'll be the court's ruling on both motions. Ms. Blake, do you have any questions on that court ruling?
No, Your Honor, thank you.
Thank you. Any questions from the defense?
No, Judge, is it permissible for me not to rise if the court preferred that?
It's fine if you don't, Mr. Pryor. That probably helps with the audio, actually, if you just go into the microphone and remain seated, so I have no objection to
I
you.
want to make sure I'm not being disrespectful.
All right, no taken. One more thing we'll put on the record before we get started with the next group. One of the jurors mistakenly noted a number that's not their number on the questionnaire, and we wanted to advise you of that. So on the seating chart, we've got juror 841. And actually let's see, so 465 is the questionnaire. That's the number of the questionnaire, is that correct? You got a questionnaire with the juror number 465. That is actually going to be red card juror number 841. So when they're in here, they should have a red card 841 that corresponds to the questionnaire with 465.
Judge, may I make a point of inquiry? Was the 465 on the file, the questionnaire, is that the number on the questionnaire, or are they actually an 841?
That is the number on the questionnaire. So the questionnaire reads 465. However, that is actually juror 841. You're welcome. All right, counsel. Took a while on that last group. To the extent we can make it any more efficient and move more quickly, I do intend to get through this group today. They've been waiting since this afternoon. So we will proceed first with the court's voir dire, then on to counsel. If everyone's ready, then we'll go ahead and have this next group of 16 brought in for voir dire. So instruct the marshals to have the jurors brought in, please.
Sure.
All right, please.
Campbell, here you are.
All right, thank you. Please be seated. All right, ladies and gentlemen, thank you for returning. Apologies for the delay this afternoon. I'm going to first, if we would do this, just to give counsel and the court an opportunity to confirm your seating arrangement that it corresponds with our chart. If you don't mind, if each of you would please just hold your red card up for a moment and give us a moment to review our charts, and we'll move on from there. All right, thank you. First, counsel, I will remind you, please only refer to jurors by their red card numbers, not by name. As I mentioned previously, we are here to select a total of 12 jurors plus 6 alternates for trial. So we're going to have a total number of 50 prospective jurors to get to peremptory challenges. The court's going to conduct its own voir dire, and I'll request the counsel not repeat questions the court's already asked. We are now broadcasting the proceedings. We are on the record on KCR 2221-1623, State of Idaho versus Chad Guy Daybell. I'll note Mr. Daybell is present, as well as his attorney, Mr. Pryor. The state's here represented by Mr. Wood, Ms. Blake, Ms. Beatty, and Mr. Wixom. First question I'll ask of counsel, beginning with the state, is there any objection to the manner in which the jury panel has been recalled and seated today?
No, Your Honor, thank you.
Any objection from the defense?
No, Your Honor.
Thank you. Ladies and gentlemen, thank you for returning this afternoon. You've been recalled as prospective jurors in this case. I'm Stephen W. Boyce, the District Judge of Fremont County, Idaho, and I'm in charge of the courtroom in this trial. My court clerk to the right is Shannon Holstein, who is keeping minutes of this proceeding and will also be administering oaths to you as jurors. We've got our courtroom marshals here, Mr. Holmes, Beige, and Ravello, who will work with keeping order in the courtroom, as well as helping you as jurors move about. The court reporter, Mary Fox, is seated down to my left, and she's keeping a stenographic record of everything said in these proceedings. And my staff attorney, Courtney Stallings, is seated to the far right against the wall, and she assists me with legal research and administrative issues that come up throughout the day. Each one of you is qualified to serve as a juror of this court, and you filled out a questionnaire that we have now reviewed. We are going to go through this process in an effort to select 18 jurors, which will comprise 12 trial jurors and 6 alternates. The clerk at this time now, using the red card number, will please make a roll call of the jurors.
Please answer audibly when I list your number. Juror 440.
Here.
Juror 465.
Here.
Juror 496.
Here.
Juror 505. Juror 526.
Here.
Juror 536. Here. Juror 539.
Here.
Juror 544.
Here.
Juror 591.
Here.
Juror 617.
Here.
Juror 631.
Here.
Juror 641.
Here.
Juror 647.
Here.
Juror 653.
Here.
Juror 686.
Here.
Juror 740.
Here.
All right, thank you. For jurors that did not appear, the court will indicate an admonishment that they may be subject to fines or jail time under Idaho Code 7610 and Idaho Code 22085. So for those of you who did appear today in this group of 16, thank you for returning. To assist you in understanding and participating in this jury selection process, again, I'll reintroduce you to the parties and the lawyers and summarize briefly what the case is about. When I introduce an individual, please stand and briefly face the jury panel, then we take your seat. The case has been brought by the state of Idaho, sometimes referred to as the prosecution. State's represented at this trial by Fremont County Prosecutor Lindsay Blake, Madison County Prosecutor Rob Wood, Specially Appointed Prosecutor Eva Beatty, and Deputy Prosecutor Rocky Wixon. The defendant is Chad Guy Daybell, and he's represented by his attorney, John Pryor. This case is a criminal matter, which means the defendant has been charged by the state of Idaho with a violation of the law. I previously read to you a summary of the charges contained in the amended indictment when you were here last week to complete your questionnaires. With regard to the defendant, the state of Idaho has alleged that he committed the following crimes. Count 1, conspiracy to commit first-degree murder and grand theft by deception. Count 2, first-degree murder. Count 3, conspiracy to commit first-degree murder and grand theft by deception. Count 4, first-degree murder. Count 5, conspiracy to commit first-degree murder. Count 6, first-degree murder. Count 7, insurance fraud. Count 9, insurance fraud. Mr. Daybell has pled not guilty to the charges. Please remember, this is simply a description of the charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I'll later give you to those facts. In this way, you'll decide the case. In applying the court's instructions to the controlling law, you must follow those instructions regardless of your opinion of what the law is, what the law should be, or what any lawyer may state the law to be. During the course of this trial, including the jury selection process, you are instructed that you are not to discuss this case among yourselves or with anyone else, including by use of email, text messaging, social media, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Don't form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, then, I am going to request that our clerk administer an oath to the entire jury panel. Ladies and gentlemen, if you please stand and raise your right hands, I'll have the clerk administer this oath.
You solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial. So help you God.
All right, thank you. Please be seated. Our record will reflect that all jurors were placed under oath. The clerk has now impaneled 16 prospective jurors for questioning in small group today. Will the state stipulate the jurors have been properly called and impaneled?
Yes, Your Honor.
Will the defense stipulate?
Yes, Your Honor.
Thank you. These jurors were sent home last week after completing the questionnaire and then provided an affirmation that they have not gone and researched or looked into the case between now and then, nor discussed it with anyone. Let me inquire next of our bailiffs. Do we know if a juror affirmation has been completed by this group?
Yes, Your Honor, and confirm.
Okay. Thank you for following the court's admonishment of not looking into the case during that intervening time period. In this part of the jury selection, then you're going to be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to origins of the common law, and in French it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand the questioning is not for the purpose of prying into your personal affairs, but only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please raise your red card number. When you're called upon to speak, identify yourself with that number. And since we're making a stenographic recording of the proceedings, please make audible verbal responses and try to avoid speaking at the same time as anyone else talking to you. That way, our court reporter will be able to keep a clear record. If any answer to a question would be embarrassing or uncomfortable for you to answer publicly, and I will note this proceeding is being live streamed, then please let me know, and we're able to discuss those issues with you in a more private setting outside of the public purview. Similarly, if your answer to any question may prejudice other prospective jurors, please let me know, and we'll also discuss that issue outside of the presence of your fellow jurors. Additionally, many of you may have knowledge of this case from pretrial media coverage and publicity. Please do not discuss any specific facts or details of this case in front of the other jurors in this pool. We can discuss those matters with you individually as needed. I'll now read to you a special instruction in this case, which is as follows. The defendant, Chad Guy Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Lori Vallow Daybell and or Alex Cox. The crime of conspiracy involves an agreement by two or more persons to commit a crime. You must only consider the evidence against the defendant in this case and should not speculate as to any other case or legal proceedings involving the alleged co-conspirators. You must remember that the defendant has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. That concludes the court's special instruction. At this time, I would instruct the attorneys for both parties to avoid repeating any questions already asked. The attorneys do have the right, however, to direct follow-up questions to a juror regarding responses they've made to previous questions. The jury should be aware that during and following the voir dire examination, one or more of you may be challenged. Each side has challenges called for cause, which means they can ask a juror to be excused for some specific reason. In addition, each side has a certain number of what are called peremptory challenges, meaning they can ask a juror to be excused without giving a reason for that dismissal. If you are excused by either side, please do not feel offended or feel that your honesty or integrity has been questioned, because it has not. At this time, then, the court will begin with its portion of the voir dire process, after which the attorneys for both parties will be given an opportunity to make their own inquiries. When other jurors are being asked certain questions, please pay attention, because you may later be called upon to answer those same questions. The first question I'll ask then relates to your jury questionnaires, which you filled out. Let me just ask the group here, are the answers given by each of you on the jury information form still true and accurate? If you would say yes, please raise your red card. Okay, everyone responded affirmatively. To the best of your knowledge, are those answers in your questionnaires also still accurate and true at this time? If yes, raise your card. Everyone said yes. Next question the court will get to is the time commitment that may be required if you are serving on this case. As you were told last week, it would be for a period of approximately 8 to 10 weeks. Would that time of service create a serious hardship upon you or your family or your business or profession or occupation so as to prevent you from rendering service as a fair and impartial juror in this case. If you think that applies to you, please raise your red card. Okay, we've got 2 jurors, 3 jurors, 641, 544, and 496. Let me take those up individually with you. So starting with juror number 496. You mentioned in your questionnaire you are out of town for work both in April and May. Could you explain a little further about those circumstances?
Yes, I have a training going on to essentially it's related to work, so I'm traveling to Arizona.
All right, would you be able to have anyone else cover, or would you be able to reschedule those commitments?
It could be rescheduled, but they're committed to prior to this case. I've committed to them.
What would be the impact on you if you were required to serve as a juror in this case and missed? And to be clear, these are 2 separate trips, both planned, is that correct? If you miss both of them, where would that leave you?
I would need to reschedule, which should be I take this trips reschedule.
All right, I think it'd be appropriate at this point for me to allow counsel to step in and ask additional questions as it relates to the hardship expressed, beginning with the state.
Your Honor, the state also had noted those planned trips and had intended to inquire of those today. Given that additional information and the expenses associated with that, the state would make a motion to excuse this juror for cause for hardship.
Judge Austin.
All right, thank you, Mr. Pryor. Ms. Blake, the court's considered the information provided today, including what you filled out in the questionnaire and your responses. Juror 496, the court will find that you may be excused for cause for purposes of the hardship you would endure if you were required to serve here. So you can be excused. Thank you for reporting. That concludes your jury service. Please drop off your questionnaire with the bailiff as you exit. And then in a moment, we'll take up our next juror that had a concern. All right, let's next talk to juror number 544. We didn't have a whole lot of detail in your questionnaire. It said you had a wedding in Atlanta. And can you explain to the court more about when that would be?
That would be April 18th to the 20th.
And can you indicate whose wedding that would be?
It is my nephew.
Have you made any prearranged purchases for that trip at this point?
Yes, I have. I actually have purchased the airline ticket before I had gotten the summons.
They willing to move the wedding out a couple of months for you? Do you think?
Kind of hard to do.
All right. I'm going to ask the state at this point if they have any questions about the purported hardship here for this juror.
Your Honor, the state also had a note on this one, and we did note there was a wedding in Atlanta. We just were unclear on the dates of that. With that additional information regarding the dates and the purchased airfare, the state would make a motion to excuse this juror for a cause for hardship.
All right, response from the defense.
Judge Austin.
All right, well, juror 544, as I mentioned last year, he will be excused based on your request to not serve at this time for a hardship that would occur if you remain. Thank you for coming in, completing the questionnaires, returning today. and your jury service is completed and you can be excused. Please drop your questionnaire off to the marshal on your way.
Thank you.
We'll next talk to juror number 641. We've got a vacation in May to visit some elderly grandparents, it looks like. Juror 641, can you provide a little more detail about that?
My vacation is scheduled for May 18th. I'll be there until end of the month. I've already scheduled time off work, which will be very hard to move. And the expense of that would total out to about 272 for the plane ticket, which I purchased in advance, and then a train ticket to visit a family friend who was recently diagnosed.
And that's incorporated in the same trip.
Yes, yeah.
All right, as to juror 641, does the state have any additional questions?
Your Honor, we also had a note here to follow up regarding that vacation in May. Again, just not a lot of information. In addition, I'd note there was an indication that there was some concern about interruption of school and work. I think given all of that, the state would make a motion to excuse juror 641 for cause for hardship.
All right, response from the defense? Okay, juror 641, you are excused based on your request of a hardship. The court determines that you won't be required to serve for this case. Thank you for reporting, for completing your questionnaire and returning today. Please drop that questionnaire off with the bailiff as you exit. For those jurors remaining, did anyone else have a concern about the length this trial may take? All right, and understandably, it's a difficult circumstance for all of us, anyone, and we do have one more now, 539. All right, your number 539, to the moment. All right, can you please explain a little more about your family situation that you believe indicates a hardship here?
I have 2 vacations planned that are each 1 week long. One is May, I think 18th to 24th, 25th, and I'm also the primary caretaker for a 2-year-old.
The May, well, both, and when is the second vacation plan?
June 1st through 7th.
All right, are either or both of those already pre-purchased or just planned?
The first one is already purchased.
And can you provide a little more detail about your commitment to childcare with the 2-year-old?
Yeah, I'm a stay-at-home mom, so I take care of him all day long, so I'd have to find alternate childcare for him during the hours that take place. And that's pretty hard to secure childcare around here, like this minute. There's lots of waiting lists.
In this case, there's a potential of being sequestered for some time, meaning you would be away from the 2-year-old for perhaps a week or even longer. What would occur if you were required to be sequestered?
It'd be really hard for him, and I'm not sure what I would do with that. My husband works that. So he has weird hours.
And do you believe that would become a significant distraction for you if you were concerned about that while being sequestered?
Yeah, he has trouble down, so.
All right, let me ask the state if there's any follow-up on these requests for excuse for hardship.
Similarly, Your Honor, the state had already made notes of those 2 planned trips. Again, we didn't have details if they had been already purchased or not. And we did have the note regarding her young child and that she was a stay-at-home mom to follow up on. Given that additional information provided by her today, the state would make a motion to excuse juror number 539 for cause for hardship.
All right, Mr. Pryor.
Judge, I will stipulate for the.
Okay, as your 539, courts considered the stipulation of the parties as well as your request, which you did request for in your questionnaire. Based on those reasons already stated on the record, you may be excused. Thank you for coming in and serving and filling out your questionnaire. You can drop the copy off with the bailiff on your way out. All right, unless there's any other concerns from the jury pool, we'll move on to another subject at this time. And again, thank you for your willingness to commit that amount of time in serving on this case if you're called. The next issue we're going to discuss is pretrial publicity or your knowledge of this case. The court would note there has been extensive news coverage of the case and other in a lot of different, published in a lot of different forms. The instruction I read previously and what I want is to not go into any discussion of any facts or details you know about the case at this stage, because we'll talk to you individually about that so other jurors don't hear what you already know. But with that in mind, if you do have some prior knowledge of this case, and by knowledge I mean not just heard of the case, but know about it in any detail, would you please raise your red card at this time?
Next question.
Yes.
You say in detail, beyond what's been on TV, or like the news and stuff.
Well, we'll probably talk to you about that individually. I know it's a generic term that might mean different things to different people. Some people have followed this a lot. Some people have just heard it in passing. Some haven't heard anything about it at all. So have you actively followed it at all? Okay, but you have heard about the case somewhat. Okay, we will ask you some further questions about that individually. Anyone else who has any knowledge of the case or? Okay, 505 and 740, 591. Okay, for you to listed your or raise your card up there on that, we are going to ask you some specific questions individually. The next topic I'll move on to relates to the subject matter of this case. Would the subject matter of this case, which involves charges filed by the state of murder, conspiracy, and insurance fraud, would that subject matter make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict? All right, no jurors answered yes to that. I'll next ask some questions that may seem obvious, and we've reviewed your questionnaires, but they're required under Idaho law for me to make sure there's no improper or appearance of improper relationship or connection to this case. So, are any of you related by blood or marriage to the defendant, or do you know him from any kind of business or social relationship? No affirmative answers. Do any of you have any kind of a relationship such as guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger between you and any of the attorneys in this case? Are any of you, and I'll know no affirmative response there, are any of you a party in any civil action against the defendant, Mr. Daybell? No one answered affirmatively. Have any of you ever brought a criminal complaint against the defendant or been accused of some crime by any of the prosecutors that are present here, including Ms. Blake, Mr. Wood, Ms. Beatty, or Mr. Wixom? No one answered affirmatively to that. Do any of you here have any kind of an attorney-client relationship or business dealing with Mr. Pryor or his law firm? No one answered affirmatively to that. Are any of you related by blood or marriage to any of the lawyers, or do any of you know any of the lawyers from any professional, business, or social relationship? All right, no one indicates they know any of the lawyers. This next question, you could just answer yes or no. If the answer is yes, we'll talk to you about this individually, but have any of you formed or expressed an unqualified opinion that the defendant is guilty or is not guilty of the offenses in this case? All right, we've got one card, number 591. You responded to that. We'll ask you more about what opinion you may have individually. Anyone else already formed some type of an opinion in reference to the defendant's guilt or innocence? Do any of you have any particular bias or prejudice either for or against Mr. Daybell as you sit here? No one answered affirmatively to that. Are there any of you who would be unwilling to follow my instructions to you as the jury as to the law that you must apply in determining this case? All right, no one said yes. Do any of you have a religious or moral position that would make it impossible for you to sit in judgment of another or to render a fair and impartial verdict? Okay, no one answered affirmatively to that. And then, are there any of you that, if selected as a juror in this case, would be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the laws instructed by the court? No one answered affirmatively to that. A final kind of catch-all question here. Do any of you have any other reason why you cannot give this case your undivided attention and render a fair and impartial verdict? All right, we have one juror raised their card, juror 465. Is that something you wish to discuss here? Do you think that's more appropriate individually?
Here's mine.
Okay, what would be a reason you believe you couldn't give the case your undivided attention?
I work nights and usually wake up around 12. Yeah.
And I'll just tell you that with our schedule, even though it doesn't look like much in my experience, this will be, it would be very difficult, if not impossible, for somebody to maintain a night shift and do trial in the day. I don't see that as feasible. So is that something you were considering when it got to the hardship question?
Yes.
Okay, so you were under the thought maybe you could work in the evenings, do this in the day?
It's more of if, when's the usual start time? Or
8:30.
that'd be like, waking up at 3 at night.
And I guess the question is, would you be able to not do your job while this case is going for 10 weeks? Because I kind of think that is what it's going to take for you to have the mental capacity to do this.
I'd be falling asleep during.
Okay. Let's go back to that question then on employment for juror number. I'm sorry, could you hold your card up again? 465. I'm going to let the state inquire at this point if you read about employment and a potential hardship here.
Your Honor, given the information provided by juror 465, the state would make a motion to excuse him for a cause based on a hardship.
Response from the defense, Mr. All right, and just to be clear, you are employed at that job full-time and that's your sole source of income?
Yes, sir.
Okay, and if you were required to essentially quit your job for the 10-week time period, would that result in a financial hardship for you?
No, sir. capability of saying what you're not in trial.
Okay, and I guess there's been a stipulation, I just want to be clear on that. I guess what I'm saying is likely you wouldn't be able to work during that time frame. So if you weren't working, in other words, if you had to quit that job to do this trial, where would that leave you?
Pretty bad.
Okay. All right, well, I've considered the responses also, the non-opposition motion from both parties. And I would find that with that in mind, Juror 465, I think it would be a hardship for you to be required to serve in this case, given the time frame and your employment situation. So for that reason, Juror 465 will be excused based on a hardship. Thank you for serving and filling out your questionnaire. You can drop that questionnaire off at the bailiff as you exit. All right, I'm almost concluded with my section of voir dire, but I'll go back and just re-ask that same question since we went through that with that juror, having listened to that. Do any other jurors here have a concern that they would not be able to give this case their undivided attention and render a fair and impartial verdict? All right, that will conclude the court section of voir dire for this panel. I'll turn this over now for the state. If you'd like to conduct your voir dire inquiry, who will be doing that? I will. All right, Mr. Wood.
Ladies and gentlemen, again, my name is Rob Wood. I represent Madison County, Idaho. Thank you for being here, and just as a reminder, when the judge said, if I ask you a question and you feel like you'd rather answer it private, just let us know. We want you to be comfortable. And there's no wrong answers here. How you feel is how you feel. And we need to know that so that this defendant and so that the state can have a fair trial. And so, Juror 505, when I say brutal honesty, what does that mean to you?
He's being very direct.
Telling it like it is. We all commit you'll be brutally honest in your responses with us. You'll tell us how you actually feel. Juror 647, do I see some hesitation? Yeah, you kind of tilted your head and looked at me like maybe not.
Oh, no, I have 4 kids.
Okay, so you can be
No,
honest.
seriously.
I shouldn't say honest, you can be forthright, that's right, okay. There were a couple of jurors that did list a hardship. That's my disputing that, but you didn't raise your hands when we were talking about it earlier, so if it's all right, I'm just gonna ask a couple of you about that. Juror 686. And I apologize, you're not one of the ones I was talking about. Juror 631. You're a medical technician, correct? And on your questionnaire, it said it may be a hardship for you that equipment at a specific hospital may not be maintained. Is that accurate?
Possibly. I was the only technician trained on this specific equipment that's not. But I've already spoken with them and they're calling the manufacturer.
Okay, so you've taken care of that so that if you can't be there, someone else can. Yep. Perfect, thank you. Juror 653. Thank you. You had mentioned on your questionnaire it could be a financial hardship for you to take time to be on this jury. Is that still accurate? Okay, so you've been able to take care of that. Perfect, thank you. Just want to talk to you really quick. As the court mentioned, we're going to get into what you've seen on the media individually later. But just really quick, does anybody here believe everything they read online. Nobody believes everything they read online. So we're all aware that sometimes there's information out there that's not true. Do you all agree with that? And what about news on the TV? Does anybody here believe everything they hear on the news? And to be clear, I'm not saying that in any way to diminish the news, just sometimes facts change, right? And we might think one thing one day and then we learn another fact another day. Has everybody seen that in their lives? Sure. And so this is so important. Can you all commit to this court, to the state, to this defendant, that what you have seen, that you'll put that aside and you'll only rely on what you learn in this court? The court talked briefly about the nature of this case and asked if the nature of this case would preclude anyone from feeling like they could serve on this jury. And just to get into to follow up on that, this is a case that involves the deaths of two minor children and a mother. And there's going to be some evidence, some autopsy photos that is absolutely difficult to look at. Is there anybody here who feels like looking at that type of material will render them unable to render an impartial verdict, that it would sway them one way or another? 591, thank you for being honest. Tell me how you feel about that.
I may get emotional if I do, but I'm a retired school teacher and I've spent my whole life trying to keep kids safe. And that, and really everybody's safe, but beyond that, I have a very vivid imagination, or I'm a very visual person. It's really more correct. So no matter what you say, I picture it already. So I'm already living in movies, so because of that, I don't watch anything violent. I don't watch action movies or anything because they stay with me and create a lot of anxiety. So, and people say, well, stop picturing it. Well, it's there. It just happens, and it has my whole life. It does cause me. I've already lost about a week of sleep over this.
Well, and I noticed that you mentioned that in your questionnaire, what you said, the vivid kind of reliving of these things. Is that a fair characterization? I don't want to put words in your mouth.
I have dreams that loop, and I have counseling and things like that, and I can get a hold of them, but when it comes to violence, it's just, okay. I don't want to say it's a character flaw because it doesn't feel like a flaw to me. It feels like it's a warning. And I'm also very intuitive, which I'm not saying that I would be able to intuit everything, but I don't know. It's like I have a different sense about me, and it's causes a lot of anxiety.
Okay. And I noticed you mentioned that as well in the questionnaire. So where this comes down, are you concerned that this vivid looping of information, of graphic information and anxiety, do you feel like that would make it difficult for you to render an impartial verdict?
I do.
Okay, thank you so much for your honesty. I appreciate that. Judge, at this time, I would ask that juror 591 be excused for cause.
Response from the defense.
Judge, can I just?
Yes, you may.
Ma'am, I'm John Pryor. I'm representing Mr. Daybell today, and I want to make it clear, I am required to ask you questions, and I don't want you to believe that any of these questions suggest that Mr. Daybell is guilty or anything like that, but if they're just questions we have to ask, would that be okay with you? There are going to be very graphic pictures here. And they're going to be disturbing to everybody. And they're going to be very, very emotional. And one of the concerns we have is that when you look at those pictures, will you immediately assign those pictures to Mr. Daybell and assume that he's guilty because of the nature and the graphic nature of those pictures? Or would you be able to look at those pictures and say, it's evidence?
I can maybe keep it to evidence, but what my concern is how I'm going to continue to function during
And this is going to cause you some emotional distress.
this.
With your association with children, having someone who's worked very hard to protect children your entire life, I can imagine. If you see those, it would be very difficult. Even if the court instructed you that, you know, you were supposed to look at these and not judge them or be inflamed or you know, overwhelmed by those, you're supposed to look at them for what they are and continue to look at all the evidence. That's going to be a difficult task for you. Do you say that's the case? Judge, I'll stipulate.
All right, Juror 591, just, I guess, a final bit of inquiry from me. I guess what I'm hearing is, you think you may get upset to the point where you're not able to pull things back together and think clearly after that? Okay. And,
I wish it wasn't true, but I mean, it is, so.
sure, different people react different ways. That's why we go through this process. Thank you for your candor to the court in these questionings. I do agree that for this juror with this particular trial, she should be excused based on that nature of the evidence that will be presented here. And so for juror 591, the court is going to grant the motion to strike for cause. And we appreciate your taking the time to fill out your questionnaire and return today. Your jury service is concluded with the thanks of the court. You can drop your questionnaire with the bailiff.
Thank you, I appreciate it.
You're welcome. You can continue, Mr. Wood.
Thank you, Your Honor. Ladies and gentlemen, I wanted to speak to you just really briefly about the law that the court asked earlier if everyone would be willing to follow the instructions as given by this court. I believe everybody answered affirmatively, correct? Anybody here have a law or a rule they don't like? People are either grinning or holding up there. We all probably have something, some rule or law we don't like. But it's important for both sides to receive a fair trial, that we can all agree on what the law is in this court, and that it is what the court gives to us. Is there anybody who feels like there may be some type of situation where they would just go with their gut rather than what the court gives? Sorry. Sure, 505. Well, and I ask, because you mentioned briefly something about that in your questionnaire. And I'm not calling you out for it, and there's no wrong answer. You can answer that however you want.
Comes from my background as a mom, that's wrong. We would do that. I don't know the instruction.
Okay,
That's why.
okay, that clarifies that. So, that you can commit to what the judge gives you as the law. You will follow that law for this case.
Yes.
Okay, Thank you for that clarification. Your Honor, I'm gonna turn my remaining time over to Ms. Blake.
All right.
Thank you, ladies and gentlemen. Thanks for being here this afternoon. I know it's getting later afternoon and you were all here last week, so we appreciate you hanging in there with us for this process. As you've already heard a couple times, we all take this very serious. We want to ensure that we select a jury that can be fair and impartial to both the state and the defendant, Chad Daybell. So that's why we go through this process. So I don't know about all of you, but I have a 2-year-old that when he wakes up in the morning, if I ask him, what do you want for breakfast? It's usually cheesy eggs. And there's a very specific recipe that I'm supposed to use to make his cheesy eggs. It's eggs, milk, cheese, salt and pepper, and usually, some extra cheese in there. He doesn't like me to vary that recipe. So I saw some people kind of smile and nod along. Do any of you have that experience either with children or someone else that you work with, and whether it's a recipe they like you to make a certain way or something they like done a certain way? Can everyone relate to that? And you're 686, I see you shaking your head. What's your experience with that?
I've had several siblings and dated several people that have children, and it's very much the same. The kid wants, peanut butter and jelly a certain way, you make it that way without any variation.
And in your experience, were you usually willing to go along with how they wanted it made?
Most of the time, yeah.
And were there times that you thought, man, if they just add this, or if they just do it this way, it'd probably be a lot better?
Yeah.
And juror 740, did you shake your head yes as well? And what's your experience with that?
Just at work and processes. People are set in their ways.
And are there times when you go along with what their ways are if it's their call to make?
Yes.
And so I know I use kids as the example, but as you're here today, and Mr. Wood touched on it a little bit already, but the judge is going to give you some jury instructions. And he's going to give you verdict forms that outline what the elements are of each count. And sometimes it's easy to say, well, it would make more sense if it was this, or why don't they add this, or why don't they take this away? But could all of you commit that this is the recipe, this is the instruction that you would have to follow? Does anyone have concerns with that? Does anyone have concerns that if you thought some part of it didn't make sense, that you'd have a hard time following that? I don't see anyone shaking their head yes on that. Does anyone here have concerns? You're going to hear from a lot of witnesses in this case. Does anyone have concerns if you hear from someone that holds different religious views than you do, whether or not you would be able to give their testimony the appropriate weight and credibility you think it was due? Does that cause anyone concerns? And so I'm someone that, while it would be smart and easy to just check the weather app in the morning, I don't. And so I'm the person that leaves home without an umbrella and then there's a rainstorm, or I dress in shorts and there's a snowstorm. So I don't know, have any of you, if you had gone to work or if you showed up today and as you got here, the sky was starting to turn a little overcast, it's turning a little gray, and you came in here and all the windows get shut and the blinds are shut while you're in here. And you go outside and you notice water on your car, you notice water all over the pavement, water on the grass, water everywhere. Would you be able to determine what had happened? And juror 653, I see you nodding and saying, yeah. And what would you determine had happened? And juror 647, would you be able to determine?
Technically, I would assume it would be, but I didn't know.
But if everything was wet all around.
Yes.
And so even though you didn't see the rain, you didn't actually see the rain clouds, you would be able to pull all of that information together to reach a conclusion. And so You may hear the term circumstantial evidence. So you may see different types of evidence in this case. Does anyone have concerns if you're only showing certain types of evidence in weighing that and giving it the weight it's due? Would anyone have concerns if you weren't shown a specific type of evidence that you thought you should see? So does anyone here watch CSI? No, we don't have the CSI people. Oh, I see, maybe a nod. Is that your 526?
I've seen it in the past.
Or the criminal minds? So if you weren't showing a certain type of evidence that they might show in a TV drama or something you've watched, would that cause you concern with weighing the evidence that you are shown? You feel that you could take whatever evidence is given you and give it the weight it's due and draw that conclusion? And the judge in this case, actually, let me back up. The judge has read off the charges in this case. So we have some counts of conspiracy to commit murder, and we have some charges of first-degree murder. Would anyone, if you're given the instruction, so we talked about that recipe, if you're given an instruction from the judge, and one of the elements is not that we have to show what the cause of death was. So the state has the burden, but if one of the elements is not to actually show what caused the death, so instead that we had to show or prove that the defendant engaged in conduct that caused the death, but we didn't have to prove the actual cause of death. Does that cause anyone concerns? Would you be able to hold the state to the burden of showing, of meeting that element that a murder had occurred, but not add an additional element that isn't in the instruction? Anyone have concerns with that? And you heard the judge give an instruction earlier today regarding conspiracy, and that is conspiracy are a couple of the charges here that you're going to be looking at today. Does anyone here have concerns? Because you, if you hear evidence regarding actions of other co-conspirators, does anyone have concerns in following the court's instruction that the conspiracy would be an agreement between certain parties to commit a criminal offense, and then one of those parties doing an act in furtherance of it? Knowing that, would anyone have concerns holding one person accountable for the actions of another co-conspirator? So if the state met the burden that all the parties had formed an agreement and only one person did an act in furtherance, if you're given an instruction that says just one person has to do that act, does anyone have concerns if holding one of the other parties accountable that didn't do that act in furtherance? So, and again, the court will be the one to give you the final instructions, but if you're given an instruction that with a conspiracy, it requires two or more persons to enter into some form of an agreement to commit a criminal act, and then that one of those persons commits some kind of an overt act in furtherance of the conspiracy. If person A didn't commit that overt act, but they were part of the agreement, would you have a hard time holding them accountable, even though it was person B that committed that overt act? And thank you for telling me you didn't understand. I should have said that. If anyone ever has any questions, please let me know. So with that additional explanation, would anyone have concerns holding person A accountable along with person B? See people shaking their heads no. Let me have just a moment. That's all the questions the state has right now.
All right, thank you, Ms. Blake. Mr. Pryor, you can conduct or dire with the group. Thank you.
Good afternoon, ladies and gentlemen. My name is John Pryor. I'm here today representing Mr. Daybell. I want to start off by telling you a little story. And many years ago, and I told it to the other folks before you, I was a juror in a jury trial. And the lawyer in that jury trial asked, is there anybody who just doesn't want to be here? And I smiled, and eventually I put up my hand and said, yeah, I don't want to be here. And it wasn't anything of a significant trial. It was just one of these things that I had so much going on as a student, a lot of other obligations that I just didn't feel like I could focus or do the job that was necessary. So I'm going to submit that to all of you. And folks, it's really important. More important than anything else, we just need to be truthful with each other. And there's no wrong or right answer. There really isn't. If you don't want to participate in something, the best thing to do is say, you know, I just don't want to do this. Because like anything else, when I have chores around my house to do, and it's time to take the garbage out, and I don't like taking the garbage out, and I'm going to do everything I can to avoid taking the garbage out. And if it's something that you just don't feel like you want to do, you know, you would generally not put the effort into it, that you would put into something that you enjoy doing or something that you feel okay about doing. So again, is there anybody here who, and please be honest, it's really what it's all about. There's no wrong, there's no right answer. It's what answer is in here, and that goes to each of you. I'm not going to judge. These folks are not going to judge, and at this point, the judge isn't going to judge. It's a play on words, I think. So again, is there anybody here who just doesn't want to be here today? Who just doesn't want to be involved in this? And please be honest with me. Is there anybody here who believes that because Chad has been charged with this offense, that he's guilty right now? No. Okay. Is there anyone who can affirmatively tell me that they're going to listen to the entire evidence in this case? I mean, all of the evidence. That means after the state of Idaho, these prosecutors put on their case, and after Chad and I have an opportunity to put on our case, that you're going to wait before you make a decision in this case. Can everybody promise me that? Put the cards in. Promise me that, please. Thank you. And I'll try not to get you to exercise this too much, okay? I'll try to be patient with all of you as far as that's concerned. Is there anybody here who feels that they can't sit for long periods of time, that they're going to have a difficulty in sitting through this, whether it's medical issues, whether it's because you tend to twitch, or you tend to not be able to sit for long periods of time, or you don't have the patience? Okay, and sir, and again, there's no wrong answer, because same thing, if you watched occasionally, I'm moving around because I don't like to sit. It makes me uncomfortable, particularly in these chairs that the state of Idaho has decided to provide for me. So why don't you elaborate a little bit on the fact about your situation?
Don't want to go into detail, just medical,
Well, if it's something that's private, I don't want to tell.
oral medical, it's breaks and things like that.
Okay, is this something that's going to cause you some pain?
Just
Okay, is that discomfort something that's going to cause you to be distracted and not be able to focus as much as you really should in something as serious as this?
usually not.
Okay, it's just something you wanted to bring to my attention. Is there any possibility whatsoever that this is going to be a distraction in any way for you?
Not a distraction for me, for the
Okay, okay, okay. You're comfortable that you think you might be able to sit through this?
yeah.
And if there's any doubt, again, you know, there's no wrong answer. If there's any doubt about that, please let us know. Okay. Is there anybody here who knows me, other than these folks who are in the courtroom behind me? Anybody in this courtroom right now from these stands forward? No? Now, Ms. Blake touched on a little bit about court's instructions. She talked about what conspiracy was and went into some detail about the fact that there has to be an agreement. Then juror 536, who needed a little bit of a clarification. And is there anybody who can't follow the court's instruction? Yes. One of the court's instructions, it's going to be in regards to a conspiracy, is that the prosecuting attorney is going to have to prove that there's an agreement, and that this agreement has to be among the parties who are accused to be in this conspiracy. Okay. Is there anybody here who doesn't understand what an agreement is? Juror number 526, what do you understand an agreement? If you don't know, that's okay. We can pass the.
You said something and something else agrees.
Okay.
They're in positive affirmation.
Positive
They have the same, opinion.
Okay. And juror number 536, you were shaking your head, and I saw that, when she said the words, and I want to make sure I say what you said, which was, I think it was positive affirmation. And juror 536, what do you think?
Be of the same thought.
They're saying specifically
To do a certain act,
Okay,
you can agree on something, not for me to do something.
okay. And juror, I'm going to reach to the back, juror number 686. How do you, yes, how do you feel about this idea of agreement? How do you define
Two or more parties come to a similar plan, agree on the details of the plan or whatever the idea is. And having trouble defining an agreement. But both parties have a similar thought and have stated that they have each other.
that? So does it have to be stated?
For an agreement. For direct agreement, yes. For an implied agreement, if everything else around it matches, then yes, but that can be argued either way.
Could be argued either way. So if you don't have the people making a positive affirmation, you have some questions about
Yeah, not entirely sure
Yeah.
how to answer that.
that. And that's okay. And it could be a confusing issue. Ken. Okay, and juror number 653, how do you feel about
I didn't say there's multiple aspects.
it? Okay,
Um, same-
okay. And I'm going to move on to juror number 647. Is it an agreement if someone is tricked into it or fooled into it?
no, because they weren't given all the information or the proper information.
So in order to have an agreement, everybody needs to know what's going on, know the terms.
Yeah.
Juror number 631, what do you think about what 647 just said?
I agree.
Okay, is that it? Straight to the point, right? And juror number 617.
I think that you don't have all the information and you're tricked into it. It's not.
Okay, all right, thank you, thank you. How do you folks? Well, I think I'm gonna pass on that judgment. You know, at this point, I think I'm gonna pass I appreciate everybody's time. Thank you very much, folks. I really appreciate it.
All right, thank you, council.
Your Honor,
Mr. Wood.
can we just ask a couple questions?
In the group setting here,
Yeah, we believe there's something that, some law has perhaps been maybe misapplied.
Judge, can we
The- the-
approach,
the-
please?
Yeah, we can approach.
Hello, hello, hello. How is everyone? Hey, everybody on X. It's good to see you. Thanks for watching with me. Are y'all like, oh, chatty boy's sitting over there by himself? Did y'all hit that thumbs up for me? Thank you, Rob. Appreciate it. It's cold and rainy here again today. I hope y'all have better weather where you are. One second. There we go. We're back. Have you ever seen a jury selection take place like this? I haven't. I thought it was going to be boring at first. I mean, it's not exciting, but you know. Wish we could zoom in.
Okay, at this time, we've concluded the attorneys for their questioning. The court's going to now move on to a phase of individual questioning for jurors on certain topics. And so we will start with our lowest number, 440, I believe. Is that you? And we'll have the other jurors excused to the jury room while we discuss individual topics with the jurors. So if you're not juror 440, please follow the bailiff out to the jury room. We'll call you back in when we get to you. All right, please. Thank you. Please be seated. All right, juror number 440, we've got some indication in your questionnaire regarding both topics of potential, what we call bias. Don't take it personally. It's a question of whether or not you formed any type of an opinion based on pretrial coverage, and the other issue of the potential, there was some concern of hardship raised in the questionnaire also that I would permit the attorneys to ask about. So with this juror counsel, if we can begin there, we'll move on to the other topic of the death penalty opinions and views once we get through bias or hardship concerns. If the state's prepared, you can proceed with individual voir dire for juror number 440.
Thank you, Your Honor. Juror number 440, I want to clarify a few things in your questionnaire to see if they're accurate, if they are going to cause any concern, or if they're not. So just starting with the hardship section, looking at your questionnaire, and I think they've given you a copy of it for your benefit if you need it, but I'm just down on page 20. And with trial length, it had indicated that your stepson's high school graduation in Wisconsin is on May 24th. I wasn't sure from that, is that something you're planning on attending?
If I could have purchased that moment, he also is planning on
And graduation from the military, you said he's just going to be joining. So it's not going to be a super quick graduation. Okay, just making sure. So with regard to that, if you were selected to serve on the jury, that wouldn't end up causing you any concern. Knowing that that graduation was going on and you were here, would you be thinking about it? Would it create any concerns for your ability to focus on the case in the matter at hand? Thank you. And then just on the other one, and I think this was in regards to sequestration, you just indicated that you have school-age children that depend on you for care. If you were to be sequestered for any amount of time in this case, would that cause you concern or hardship?
I would say not too much. You're pretty independent when I'm not around. I give you less on that phone. And I have family that lives by that.
And so you think if you were to be sequestered, you'd be able to figure out the child care? Thank you. I just wanted to make sure that I wasn't missing anything additional there. So thank you for that. And then just looking with regard to bias, and I'm looking at page 19, There's just the question, it's F actually. If you formed a personal opinion regarding Chad Daybell's guilt or innocence, you'd indicated yes, and then you wrote, I do have an opinion, though it has been based only by what the media has reported, which is not always accurate. What exactly did that mean with regard to your opinion?
I know that not, media is not, doesn't have all of the facts, and what they do have might not be accurate. So just knowing that, I see the news reports and, that has caused me to form an opinion, but I feel like, whatever the facts are presented, that would change how it.
And when you say that could change how you feel about it, would you be willing to share how you feel about it right now?
Based on what I have seen, saying this.
And knowing that the court, we talked about the recipe and following the court's instructions. Knowing that the court will give you some instructions, do you feel that you would be able to follow a court instruction to set aside anything that you've seen in the media and base any verdict only on what's presented in the courtroom in the trial in this matter? I don't have any further questions, Your Honor. Thank you.
All right, thank you, Ms. White. Mr. Pryor.
In terms of communication,
Very well.
is that better? In terms of the trip to Wisconsin, are you driving or are you flying?
We would fly. If my husband goes, he's going to fly. But we haven't made any type of formal.
Okay. And it's a desire, for both of you to go, though. Okay. Is it going?
Financially, it might not. be for all of us to go.
Okay. So there really hasn't been a determination as to whether you're all going or not, but you just have a desire to go. Is it going to cause you any anguish or cause you to lack the ability to focus on this at a time when this graduation is going on and you may be here as a juror in this case? Okay, and thank you for your honesty. I really appreciate it. Judge, if I could just have a moment, please.
Yes.
You made a comment that you formed an opinion. And you said, however, the media may not always represent things as they actually are, and that there could be some slant in the way the media reports things. Is that fair?
Yes.
Okay. But at this point, you have an opinion about this case, correct? And may I ask you what that opinion is? Okay. Now, are you going to maintain that opinion and say, well, I think he's guilty, and that's what your opinion is right now, correct? But if you see other evidence that suggests otherwise, you're open to changing your opinion. But at the present time, as you stand before us right now, you believe that Mr. Daybell is guilty, and that's the opinion you're going to go forward with unless evidence is shown to suggest to you something differently. Would that be fair?
Yes.
Okay, Judge, I'm going to move for cause, if I could, please.
All right. Courts considered the responses here. Based on those responses, juror number 440, and going to sustain the challenge for cause for bias. Again, nothing personal or trying to find jurors that don't have a preconceived notion of guilt or innocence. Just because you do, nothing wrong with that. You follow the news as many people have. And in this particular case, we're attempting to find jurors where the defendant's not improperly working against an assumption or bias someone may have. So for that reason, juror number 440, I am going to excuse and uphold the defense challenge. Thank you very much for filling out your questionnaire, for your honest answers today. Thank you for taking the time to come back in, and please drop your questionnaire off with the bailiff as you exit. All right, let's next have juror 505 return. All right, juror 505 has returned for individual without questioning. Just briefly reviewing the questionnaire again. You do have some prior connection or knowledge of one of the potential witnesses in this case, Greg Pekian. An additional concern may be some coverage you followed in the news. And so I'll let the state follow up on any additional Bodar individuals for this, sure.
Thank you, Your Honor. Juror 505, you mentioned you have met Greg Hampikian. What was the nature of your meeting with him?
So I'm an auditor where he works. I audited his guards one time.
Okay. And was there anything about that interaction that would cause you to give him greater or lesser weight as a witness? So you could take him as a witness with a clean slate and just weigh it, whatever he said against all the other evidence. You mentioned that you had seen, you think, a Dateline.
I saw a special. My wife watches Daybell, so I put that down.
Okay.
Yeah, it was one of the specials.
And I noticed that you thought it was that, but you weren't sure exactly that's what it was. Do you recall when you saw this special?
That was more than a year ago.
Okay. And do you recall that, not that you need to say it all, but the content of that special, what it was about?
No, just the basic, pretty much what's been on the news. I recall.
And was there anything in that special that led you to lean either way as to the potential guilt or innocence of this?
Not really. I don't remember it, to be honest with you, so not very special.
Okay, so you remember seeing it, but you don't really recall the content too much. And you feel like you can, whatever you did see, it didn't cause you to form an opinion, correct? And you feel like you could put that out of your mind and render an impartial verdict. I did notice it said in your questionnaire, you've had some training in forensic accounting.
Yeah, no, it's certified audit.
Okay.
I used to be for the ACFE chapter president.
Okay. So that, without going into detail, there will be some evidence in this case that deals with accounting of funds at some level. Having that expertise you have, Are you going to, do you think you might be kind of critiquing that accounting either way?
You know, it'd be hard for me to turn that off. No, right, but, it's another professional's. way of thinking about it. It's what we do.
Okay. And so would you be able to look at that evidence, in a light that it's shown and weigh it against all the other evidence?
Yeah.
Okay, so neither of this defendant or the state has to worry that, you'll get hyper-focused on one portion of the case. So, and I always say that because I kind of do that sometimes with, so, I have nothing else about bias.
All right, thank you, Mr. Wood. Mr. Pryor.
No, nothing, Judge, thank you.
All right, thank you, counsel. The next matter the court will discuss with this jury then will be as it relates to your questionnaire, starting page 12. We have a section in here called attitudes regarding the death penalty. Juror number 505, do you recall reading through those questions and filling out the answers for those questions in that section?
Yes.
And do you still concur with or agree with the answers you provided in the questionnaire?
Yeah, real quick.
Yeah, go ahead and review them, and that goes on for about 2 pages to the end of 13.
I think, yeah.
Very well. As we mentioned earlier in the proceedings, in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember that any penalty you consider should be considered as if it is absolute and will be carried out in this case. So with that in mind, knowing this is not a hypothetical set of questions, but questions about this case, you've indicated on your questionnaire, I'll note, there's a line that says, do you support or oppose the death penalty? There was not a response or check there. Was that something you intentionally passed over because you thought it was yes or no, or did you just forget to answer it?
I had a tough time answering on didn't.
Okay, so you considered it, you didn't have a yes or no? Very well. You next indicated you would, it says, do you feel your views on the death penalty would prevent or substantially impair your ability to view the facts impartially? You said no. Do you still agree with, although you have mixed feelings about it, that you would be able to view the facts impartially?
Yeah.
The box you circled, or letter on page 13 that you circled on that bottom set of choices for what most accurately represents the way you feel. You selected choice C, which says, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in this case. Do you believe that is an accurate statement of how you feel about the topic?
It's the closest one out of those choices.
Okay. One final question then for the court. Do you believe that you'd be in favor of the death penalty in every case where a murder has been committed? Okay. Regardless of your personal thoughts then, in this case, is there anything that would substantially impair your ability as a juror to perform your duty in accordance with the court's instruction, even if that meant considering the death penalty?
No.
All right, thank you for your responses. That concludes the court's inquiry on that topic. From the state, any questions on board?
The state doesn't have any questions regarding this issue.
Thank you. Mr. Pryor, any questions for the defense?
And sir, you mentioned that under item number 6 on page 13. Well, let me know when you're there, sir. I'll be there. Okay. You circled number C. And if I'm not mistaken, you said, well, that one's the closest to the way I feel. Would it be
I think if that is support or not, I would be more towards supporting, but
Would it be fair to say that you're neutral?
that's probably close.
And if there was a choice between C and D that said, I am neutral on the death penalty, would that be a fair assessment that you'd be neutral on the death penalty?
That was an option.
You would have circled that one? Okay, thank you. Thank you for your time, sir. Judge, I have nothing.
Okay. Juror 505, that concludes your individual voir dire. I'll have you return to the jury room with the bailiff to wait for further instructions as we get to the other jurors this afternoon. So next have juror 526. All right, welcome back, juror number 526 for individual voir dire. The court does not see much in the way of any prior case exposure or knowledge. There is some mention of hardship that may be addressed. If the state would like to inquire as to that, then we'll move on to our next topic after hardship's addressed.
Thank you, Your Honor. Ma'am, hi. You indicated that you offered dog boarding in your home. Is that something that you do for income?
Yes.
And so if you were selected as a juror in this case, would a 10-week trial cause you financial hardship?
No. No.
Do you have any pre-existing arrangements or contracts to provide that service with anybody that you would have to cancel or anything of that nature that would provide you hardship? Would be a hardship.
If I was chosen, then I would let the families know that has booked me. That's something, and I'm no longer available. It's that kind of thing.
Okay. Thank you.
Sorry, I tried.
It's okay. You also indicated that you have a little boy who has a birthday on June 1st. Is that correct?
Yes.
Is that going to be a local celebration or would it be something out?
It's supposed to be at my house.
Would there be something about throwing that party or having that celebration that would create a hardship for you that would make you unable to serve on this jury?
No.
Okay. Thank you very much. I have no other questions at this time.
No questions.
All right, thank you. The next topic then for juror 526 we're going to discuss is as it relates to the responses you provided in your questionnaire about attitudes regarding the death penalty. So that's a section within the questionnaire starting on page 12. Do you recall reading those questions and providing answers to those questions?
Yes.
And are the responses you provided when you filled this out last week still accurate in the way you feel today?
Yes.
Okay. In the first response, how do you feel about the death penalty? You said, I do not believe in it. Later on the second page, 13, there were some choices there. And you said what most accurately represents the way you feel would be choice D, quote, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. So I'd like to ask if that is still the way you feel about that topic as you sit here today?
Yes, it is.
Okay. And understand, here in this case, we're not just dealing with hypothetical questions now. I would advise you in this case that it may well be necessary for you to make a determination, in this case, if you serve on the jury, in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. So with response to that, you did state that although you may feel opposed to it, you would still follow the facts, law, and instructions in the case, and if required, would be willing to follow those instructions on the death penalty. Is that the way you feel as you sit here today, knowing you may serve as a juror in this case?
Yes. Kind of like what you were saying earlier, the recipe that you're given. Does that make sense?
It does.
It was the,
So although it's something you may not be in favor of or like or agree with, if that's the law and the court tells you that is the law, you would be willing to follow an instruction in this case to follow that law.
yes.
All right, that would conclude the court's voir dire as to this particular juror. Counsel for the state, if you'd like any follow-up, I'll allow that as well as the defense.
I don't have any questions, Your Honor. Thank you.
All right, from the defense. All right. That'll conclude our individual voir dire for juror 426. Thank you for coming back and your answers. The bailiff will tell you what happens next, and we'll have juror 536 brought in. All right, juror 536, thank you for returning for some individual questioning here. Reviewing your responses, let me first ask, are all the responses to the best of your recollection still accurate that you provided in this questionnaire?
Yes.
Okay, thank you. There's been some indication of previous knowledge of the case and perhaps an opinion expressed by this juror regarding guilt or innocence. I don't see much in the way of a concern for potential hardship. So for the state, if you'd like to inquire as it relates to any potential bias, I'll begin there and then I'll move to defense.
Thank you, Your Honor. Excuse me. So ma'am, the other question now with you. I might reference you to some pages just to make this a bit easier. I might call your attention to page 15. Excuse me. My first question, at the bottom of page 15, you did make an indication that you learned some things about this case from local news, and you mentioned perhaps Daybell or some other special. Is that right?
Maybe, yeah, I watch a lot of shows.
Okay. So then I would just draw your attention down to the next question. It says, I have an opinion that he was involved. That's referencing Chad and Daybell. Can you explain that more? What did you mean by your opinion that he was involved? What do you believe as you said that?
If we could mute the on-table mic while we use the handheld, I think Okay, thanks.
You're right now, so perhaps. Sorry, ma'am, did you get that question?
Yeah, so when it was first in the news with the kids missing, it just seemed like a really long time went by and seemed like there were claims of no knowledge at all, or that they were with someone else or. So it just seemed like there was a lot of time that passed where there was no voluntary knowledge of what might have happened.
So without wanting to put words in your mouth, I don't. Is it accurate then to say that you're not sure exactly what you believe he was involved with, just that there was involvement? Is that a safe way to say it?
Yeah.
Now, you understand that, as Mr. Daybell sits here today, until the state completes our job and proves he's guilty, he's got the benefit of a presumption of innocence. You understand that? Okay. When you make the comment in your questionnaire about you believe he's involved, do you think that's going to impact you and your ability to presume his innocence until you believe he's been proven to be guilty?
No, I know that I need to go by the evidence that we are given.
You're prepared to do that?
Yes.
Okay. I next like to direct your attention back, excuse me, to page 19. On page 19, the very last handwritten response that you made, it says, I can't think of any specifics to specific involvement or specific actions. And that was in response to a question about an opinion. Did you have any other opinion about Mr. Daybell or this case besides that you believe he was involved in some way?
No.
You on the bias portion, Your Honor, I don't have any more questions for this chair, but I may have some others.
Thank you. Mr. Pryor?
Juror number 536. You made the comment that you think he was involved. Was that based on the facts that you had heard some time ago and said, looking at this thing, it seems like he has some involvement in this? Would that be fair? Or is that how you feel at the present time?
Well, I guess both then.
Okay. Okay, so going into forward, if you were to be chosen to stay on the juror, is your mindset that he's guilty right now and I'm going to have to prove that he's innocent?
No.
Okay, and that's really what I'm trying to get at is, at the present time, you have information based on what some of these folks in the media have provided to you, right?
Right.
And you recognize that that may not have anything to do with the truth.
Right.
And you may recognize that when media outlets and all of these TV shows that talk about this stuff, they have a tendency to sensationalize things.
Yes.
It's what sells. I mean, newspapers take all sorts of liberties. TV shows take all sorts of liberties because they have to do that gotcha thing.
Right.
You recognize that.
Yes.
And at this point, you don't have any bias or you haven't made a decision that Mr. Daybell is guilty at this point. Is that fair?
Correct.
So you would be agreeable to looking at all the evidence. That includes what the state of Idaho does and those prosecutors and what I put on before you actually make your determination of what you're going to do.
Absolutely.
And you will guarantee to all of us that's the process you're going to go through. I appreciate you walking through this, and you understand how important that is, correct?
Yes.
And I'm not trying to talk down or be condescending in any way. I'm just trying to make sure that step by step, that we both recognize that it's really important that you look at all the evidence and hear what everybody has to say before you say, this is how I feel about this case. And would you be agreeable to that?
Yes.
Judge, that's all I have. Thank you very much, Your Honor.
All right, thank you. All right, juror number 536. The next topic I'd like to cover with you, and I'll have some questions and statements, and after that, I'll allow counsel to inquire as well. This relates to attitudes or questions regarding the death penalty, and that's what begins on page 12 of the questionnaire. You recall reading those questions and considering and thinking about your thoughts on the death penalty.
Yes.
Are the responses that you provided still the way you feel and accurate today?
Yeah.
Okay. As I stated early in the proceedings, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. So remember also, any penalty we're considering or discussing here in this case should be done as if it is absolute and will be carried out in the case. So with that in mind, you've made responses that on part B, you say, do you support or oppose it? You indicated you oppose it. Is that correct?
Yeah.
And when given just that yes or no answer. Okay. You next indicated in the next two questions that would not impair your ability to view the facts impartially. You still agree with that?
I do.
And you still agree with that would not impair in your ability to return a guilty verdict if the state had proven its case beyond a reasonable doubt?
Right.
Okay. If you look over to page 13, when you were given your choices on pre-written summaries of what you think most accurately represents the way you feel, you selected choice D, which reads, I'm generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Do you still think that would accurately represent your feelings about the death penalty?
Yes.
Okay. So knowing here you may potentially serve in a case where that is something you would have to consider as a juror, let me ask you to confirm, would you be willing to follow the court's instructions on the law, even if you may have some opposition to the death penalty, and follow any instructions given to you, even if it required you to consider that in this case?
Yes.
All right, that will conclude the court's questions as it relates to that particular topic. Moving on to the statement, any questions from the state on that?
Yes, just a couple, Judge. Ma'am, I don't recall if the court specifically asked this question, but on page 12 of your questionnaire, the first question about the death penalty, you ask, how do you feel about it in response? That fiscally, it seems like it tends to waste money with appeals. Can you first explain your perspective on that? What do you mean by that?
It just seems like there's a lot of money wasted. And with the appeals and everything, it just goes on and on. So, you know, life in prison is a lot of times what they usually end up serving anyway. But there's just a lot of money spent there.
So is it accurate to say that with that statement, do you feel like a death penalty imposition wastes money because of the appellate process? Is that what you were trying to say or not? I don't want to put words in your mouth.
Yeah, that's what I mean.
So then if that's a feeling that you have, and again, we are just asking you to be really honest, would that feeling have any influence on you when you are listening to the facts of the case and after the verdict you're asked to consider the death penalty? Will that feeling that imposition of the death penalty is largely can be a waste of money. Would that influence your willingness to decide to impose it or not?
No, because it's the law here.
Okay. Your Honor, if I may, I had missed one bias statement. May I go back to that topic? It was just one statement.
Go ahead.
Thank you. Ma'am, I do want to go back to the issue of potential bias. On page 15 of your questionnaire, there's a question number 5. It says, could your knowledge of Chad cause you to give either greater or lesser weight to these statements I made? You said yes. Then in your explanation, you wrote, since it seems like he's been untruthful, I would not necessarily believe all statements. In what way have you come to believe that he's been untruthful? What do you mean by that?
Well, I guess first of all, I want to say that I don't necessarily believe everything anyone says. So, yeah, to have the amount of time, like I said before, that it was in the news, you know, where the kids and I'm assuming that there was some untruthfulness going on during that time. But yeah, I don't know for a fact.
Okay. Well, thank you. I'll just leave it with the last question. And so that feeling that or assumption that he was in some way untruthful, is that something that you can set aside and still give him the presumption of innocence until we can prove that he's guilty?
Yeah, but I won't necessarily believe every statement that he makes just because he says the words.
So is it fair to say that you maybe have a bias as to his credibility if he were to take the stand and testify? Is that what you're saying? And I'll remind you, the judge will likely instruct you that you don't have to believe all of anybody's testimony or none of anybody's testimony. It's entirely up to each juror to decide what portion of any witness's testimony they choose to believe. So with that understanding, do you feel like this assumption that he's been untruthful is going to cause you to be unwilling or unable to presume that he's innocent?
No, I will look at the evidence that would support either way. Innocence or not.
Thank you. I don't have any more questions now.
All right, thank you. Mr. Pryor, either on any follow-up to that bias topic, I'll permit, as well as any questions you have regarding the court's questions on the deputy.
Okay. And ma'am, part of your job, you understand, is to not just look at Mr. Daybell as anything he may have said, but you're also going to be looking at every single witness. You're going to be looking at police officers. You're going to be looking at witnesses. You're going to be looking at experts. Part of the process is to determine who you believe and what you believe. You agree with that, right?
Yeah.
And part of that is statements made by Mr. Daybell or anybody else. Part of your job is to evaluate and say, listen, I believe this, I don't believe this. And if you're doing the job of a juror, as you seem to be suggesting you will, that analysis will go on throughout the trial and you making a determination who, what, where, when you believe. That be fair?
Yes.
And then lastly, your comment about death penalty, and this is at the bottom of number 12. And this is I promise this is going to be my last question. Okay. I promise.
Yeah.
You said, do you feel the death penalty is used and you check too often?
Okay.
Yeah. And then you wrote in there, between the fiscal reasoning above, mistakes also happen. So this isn't saying that you're going to vote automatically against the death penalty, but in general, you're leaning that, you know what, I've got to be fair and look at both sides before I really make a fair assessment of this. Would that be a fair statement?
Yes.
Okay, all right, and thank you very much for your time. I really appreciate it. For us. Nothing else, Judge. Thank you.
All right, thanks, council. That will conclude the individual voir dire for juror number 536. Thank you for answering those questions. We'll have you return with the bailiff to the jury room to await some further instructions before you're released today. And thank you for your patience. Juror number 617, we'll talk to next. We'll need a quick break, or should we keep going? I mean, I think we might be another bit here. I'm inquiring for staff too. Are you okay, Mary? Okay,
The state's okay.
thanks.
Sorry,
I just asked if anybody needed a quick break or recess before we got through the rest.
I think we're ready to just push through, Judge. Thank you.
All right, thanks. Welcome back, juror number 617. This is the time we got you here for some individual questioning on these questionnaires. I'll note there's been a minimal discussion, but some knowledge of the case and not much in the way of hardship. So if the state would like to make any inquiry as to any potential bias, we'll start there and then I'll allow the defense to follow.
Thank you, Your Honor. The only thing I saw on potential bias, so I just wanted to follow up with you. It looked like you had maybe limited media exposure or limited knowledge of the case. You had written a statement on a question regarding your ability to act impartially. You had written, I would try to act impartially. So I was just going to follow up with you as to what you meant by that.
Yeah, because I don't know how you could live in Idaho and not know about the case. And so try to, at least I've tried to, you know, especially, I haven't, you know, watched it all the news, when the reference comes on since, and actually I stopped watching it because it sort of beating us up with it a long time ago. Yeah, it was on Daybell and everything. So I think it's important to try. Like I said, I do my best and listen to the evidence and stuff because I think a jury, serving on a jury, it's like one of the things of the American that we do. Here, you know, the economy, you're off a trial by a jury of your peers. And so it's to me, it's almost like it's like something you're supposed to do as an American citizen. Try to, you know, do your best for the person, for everybody. Like you said, for both sides, actually talk today.
And when you talk about the media coverage that you saw, and you said that you will try, and I appreciate your honesty. So knowing everything that you've seen and heard, do you feel that you could set that aside and act impartially, or do you still have concerns as to whether or not you'd be able to do that?
You know, I would try to bag it up. It's like they said, I stopped a long time ago. Like, I didn't even watch the Dateline thing or Dateline. And because it's just been overwhelming. Anyway, yeah, I think I can set it aside. I'll do my best.
I don't have any further questions. Thank you for that.
All right, thank you, Mr. Pryor. All right, next topic then, juror number 617. There is a section of the questionnaire that you filled out and it's entitled Attitudes Regarding the Death Penalty. Do you recall reading through those questions and answering those?
Yes.
And are your responses contained in your questionnaire still accurate as to the way you feel as you sit here today?
It is.
Okay, I'm going to walk through some of these responses you have here. The first, you made a comment in opposition, and also it says, do you support or oppose the death penalty? You indicated you oppose it. Is that accurate?
Yes.
All right. Now, just so you know, that what I'll try to resolve here are your responses on that part C and D with the response you have on the next page. And again, we're just getting information. So I'm on page 12. And kind of right in the middle of that page, there's a question C, 1C on page 12. And it says, if you've located it, do you feel that your views on the death penalty would prevent or substantially impair your ability to view the facts impartially? And you said no. And then the next question, do you feel your views on the death penalty would prevent or substantially impair your ability to return a guilty verdict of first-degree murder against the defendant, even if the state had proven its case beyond a reasonable doubt? You said no, that would not impair that ability. At the bottom of the page, you say it should never be used. And then if you just flip over to page 13, and I'll have you finally review your response at the very bottom of the page where you circled G.
Yeah, I strongly believe that.
Okay, so the questions I'm going to have following up, if in this case the court were to give you instructions indicating that you had to consider the death penalty, and let me go back before I finish that comment and say to you, as we've said, in this case, it may be necessary for you to make a determination. So this is not a hypothetical, and a determination in regard to imposing the death penalty or some other penalty. And also, you have to consider here this, you should consider that this could be done and it would be absolute and would be carried out in this case. So if that's what you are considering, if the court were to instruct you that you were to consider death penalty, would you be willing to do that?
I'm sorry. If that's the only option, I wouldn't be able to do that. We couldn't vote for life, for all things like that.
Okay, so if that's the case, do you think your views now on the death penalty would prevent or substantially impair your ability to perform your duty and follow jury instructions if those instructions were included here?
Okay. I have a hard time being with it because I don't know how your instructions will go. I can't imagine you going, go back and sentence this guy to death. If we're given the choice to do the penalty, why couldn't we vote for life in prison without parole? But if the only choice is the death penalty, I couldn't do it. Truly could not do it.
Okay, and again, your personal views are absolutely protected and allowed, and we're just getting to a question of whether or not you are able to serve in this particular case where this is an issue. I guess another way I would ask it then, and just to be clear, it's not necessarily some sort of voting system, but in terms of an instruction you would receive of considering how much proof there is or is not to determine if the death penalty should be imposed. If that's where this case ended up, are you telling me unequivocally that you would not be able to follow an instruction if it required you to consider and or impose the death penalty if the state gave you enough evidence that you had to do that?
Sure.
You would not do it under any circumstance. Okay, thank you so much for your candid responses. Let me ask the state if they have any follow-up for this juror.
Your Honor, the state has no follow-up questions, but would move to excuse this juror
All right,
based on those responses.
Mr. Pryor.
okay. Ms. Blake, please repeat, and then I'll go on to Mr. Pryor's position.
Your Honor, based on the juror's response that he unequivocally could not impose the death penalty, if it came down to that, the state would move to have this juror removed for cause.
All right, there's been a challenge here, Mr. Pryor. What's the response? And you may inquire on or Dyer if there's any rehabilitation.
Judge, may I pursue some rehabilitation?
Yes,
And Judge, can I have permission to stand up? We've been sitting for some time.
if you'd
May I
like,
go to the
yeah,
Podium.
you may approach the podium. Just make sure you use the microphone.
And juror number 617, I want to clarify something. If you were chosen as a juror in this case, and the judge gave you an instruction that said you were to consider either life imprisonment as an option or the death penalty as an option, would you follow the court's decision and agree to consider both of those? Would. Okay. And let me finish that if I could, sir. Would it be fair to say there are circumstances that you would consider the death penalty? Okay. Could I give you an example? Would you mind talking about this a little bit with me? Sure. Okay. It sounds like when you made mention that you think that it's a high honor to serve on a jury and it's our obligation as citizens. Would you agree with me in that regard? Okay. And as a high honor, it's also part of our laws of our country to protect our country. Our president's job is to protect our country. So there are very brave military and our police officers and all of the folks that are involved in any aspect of law enforcement. If we were attacked in a foreign country and they started engaging in genocide, do you understand what genocide is? Yes. And they started killing people needlessly. And at some point there was some sort of trial. And it's an egregious act. Children, young people murdered on the streets. Horrendous acts of violence against people and our citizens in this country. And at that point, we have to make a decision. And the options are to consider the death penalty. And if it means we have to take actions in order in the future to protect our country, is that a situation where you would consider, voting to impose the death penalty on a situation like that?
I didn't come by this lightly. It's who I am. And I believed it for years. I believed it from my teens. And once I joined the Catholic Church, my Pope said it's just reinforcing. It is part of my makeup. I have it in my family. If I was killed, if I died by another person's hand in a violent act, my family is not to let the prosecutor pursue the death. I understand, and I have, and I think I'm a loyal American. I would defend this country, and stuff, but it's different in a war, you've taken somebody's life, but I don't feel it's right. I don't feel it's justice. I feel it's revenge. I'm sorry, I will not, I cannot vote for the death.
And so there's no apology needed because you know what? I think I spoke with all of you folks earlier and said, there's no right or wrong answer here. It's what each of us individually believe in our hearts. So there's no need to apologize because what you believe, what we're trying to establish is, and my questioning is not to get you to change your mind. That's not what my intent is here, sir. What I'm trying to do is find out whether there is a very narrow exception that says, yes, there are exceptions where I would consider the death penalty. They would be very narrow, but I'm not absolute. I've got some situations where I would consider that. But I think you've answered my question. And I appreciate your candor and I appreciate everything. I'm not trying to disparage you or in any way. As I stated to all the other jurors, there is no right or wrong answer. It's what each of us honestly believe and to tell the court what we believe in. And I want to thank you for your honesty. Thank you, sir.
All right, the court has considered the motion to strike as to this particular juror number 617. The juror stating unequivocally they would be unable because of personal views and beliefs to follow or unwilling to follow an instruction if it involved imposition of the death penalty. The court finds there is cause to strike juror 617. Thank you so much for your candor in expressing your opinions on that issue. You can be excused with the sincere thanks of the court for your service today and for last week filling out the questionnaire. And we will go ahead and discuss this with another juror, and you can be excused. Please drop your questionnaire off with the bailiff. Juror number 631. All right, thanks for returning juror number 631 for individual or dire counsel. There's a bit of a expression of concern on hardship, and there was a request for hardship excuse. Let me just start off by asking for a little more detail. You stated maintenance of medical equipment at a hospital. Can you explain how that issue would be addressed by you if it's still a concern?
At the time, I was the only technician trained at our hospital. We worked on anesthesia machines. I've spoken with management about that. They will call it outside if I do selected.
Okay, so you no longer have a concern about a possible hardship if you're required to serve in this case?
No.
Okay, thank you for clarifying that. Counsel, I don't see any other grounds of inquiry in terms of bias or hardship, so I would propose we move on to the next topic. Does the state agree?
Your Honor, if I can just ask one question.
Go ahead, Mr. Wood.
Juror 631, would this pose any type of financial hardship?
No.
Okay,
My company pays for it.
that's it. Your Honor.
All right, any questions?
Judge.
All right, so the next topic the court wants to discuss with you then, juror 631, is in relation to your attitudes regarding the death penalty. You filled out a section in your questionnaire starting on page 12 there and advised us of your views on the subject. Are the responses you made there still accurate in the way you feel as you sit here today?
Yes, I just so.
Okay. Let me advise you in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And when you're thinking about that, you should consider that it would be done as if it's absolute and would be carried out in the case if that was your decision. So with that in mind, looking at your questionnaire, you've stated on the B section in the middle of page 12 that given a choice of support or oppose the death penalty, you indicated you support it. Is that still the way you feel? Okay, and then just given a choice of selections about what accurately represents the way you feel, on page 13, you circled paragraph C, which reads, quote, "I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions of the case," end quote. Is that still, you think, a accurate representation of your thoughts on the death penalty? Okay, where you've indicated you would follow the instructions if required to do that, one other question I'll have for you then. Would you, pardon me, would you be in favor of the death penalty on every case where a murder's been committed?
It depends on the case.
Okay, so if the instructions were there that you were to consider it, you would be able to consider it? If you were not instructed to consider it or instructed not to consider it, would you be willing to follow those as well? Okay, that concludes the court's voir dire of this juror as it relates to the death penalty. Is the state wishing to have any voir dire on that issue? All right, from the defense, any questions?
Just a few. So I'm looking at your questionnaire and it's on top of page 14. Could you refer to that for me? And I'll read that as best I can. If you were in favor of the death penalty in some cases, do you agree that a sentence of life in prison rather than the death penalty would be appropriate under proper circumstances in some cases? And you marked the no. So I guess I'm just, and this is not a quiz or anything else. Obviously, I think we spoke earlier, and I mentioned that there's no right or wrong answer. It's what each of us personally believe in our hearts. And that's what we were trying to arrive at here. What are your personal beliefs and what are those beliefs? 16 or 20 people, everybody has different beliefs. But there's no right or wrong. You get to say what your beliefs are and let us know so we can do an assessment of where we think whether you fit here or not. Is that fair? Yeah. Okay, so when it says that you would not consider life in prison as an option, if for some reason, and this isn't sort of applied to Mr. Daybell's going to be found guilty, but if we are in front of and the jury makes a decision that it's a guilty verdict, and the court gives you a life sentence as an option, and the death penalty as an option, and you have to decide which of those two you're going to choose. The way I'm reading number 7 there is that you will always choose the death penalty.
I didn't interpret that question that way.
Okay, okay. So is it fair to say then that under certain circumstances, you would not impose?
Yes, it would depend on the circumstances, yes.
Okay. When you're looking at those items, A, B, C, D, E, and F, and G, that would be on page 13. Did you go to 13 for me? Do you mind? Let me know what you mean. You marked number C. And then right below it is number D. And the only difference between C and D is C says I'm generally in favor of the death penalty, and D says I'm generally opposed. But both of those say I'm going to consider other options. Would you agree with that? With that both of they're relatively close with the exception. One says generally opposed, one says generally agree. Am I confusing you?
A little bit.
Yeah, I'm sorry. In looking at those, you mark number C, and then right below that is number D. Did you see number D? And it's basically the same writing in D, except the first part says generally opposed. You see how that's written? Okay. Would it be fair to say that you're between the generally opposed and generally agreeable, and that you're more neutral on this, and you're gonna take time to look at the facts of the case and make a determination how you're gonna vote based on the facts of each individual case?
I suppose so, but I'm not opposed to the death penalty.
And I'm not saying that, but, I'm not necessarily saying you're not opposed to it, but when given that opportunity, if that should happen, you're gonna weigh both of those equally, aren't you?
Yeah.
And you're not gonna rule one way or the other until you have all of the facts and make an informed decision of which way you're gonna go. Would that be fair?
Would that be fair?
Okay, is that how you would feel in this situation? And you would be neutral and weigh the facts one way or the other before you make that final decision? Well, I don't want to put words in your mouth. Is that how you feel? Or do you feel that you really just agree with the death penalty, and that's where I tend to be wanting to lean? I guess that's what I'm trying to establish here.
I would say I'm not opposed to the death penalty. It's on the table, and, if I feel it's needed, then that's the way I'm going to.
Okay, so you're gonna look at both circumstances then?
Yes.
Okay, and Judge, I have nothing else. Thank you very much.
All right. Juror number 631, then that will conclude the individual for Dyer. Have you returned to the jury room? Thank you for your patience. I know it's been a long day for you today. We'll have you instructed further as soon as we can. We've got a few more to get through, and then we'll call you back into the courtroom shortly. Juror 647. All right, juror 647, thank you for returning. We're going to conduct some additional voir dire here. The court wanted to first address issues of potential bias. I don't believe there were any concerns regarding hardship. Counsel, the court did offer a special instruction, and I would note that this juror has some specific knowledge of the companion case. And so perhaps those are appropriate lines of questions here too. I am going to let the state first inquire as to whether or not there would be a bias to be considered, and then I'll let the defense proceed after that. So who's conducting voir dire here for the state? All right, Ms. Beatty, go ahead.
Hi there. Just a few quick questions. I saw that you had seen a little bit about this case on the news. And I want to specifically talk about on page 15, you indicated that you had seen on the news that Lori Vallow was recently found guilty and sentenced in her case. Knowing that, would you be able to take Mr. Daybell, the defendant, and give him a clean slate and a presumption of innocence going into this case?
Yes.
Fair and impartial. Okay.
And there's nothing else that you saw about this case that would influence your decision-making process in any way. And just, you understand that what you've seen on the news or heard on TV or social media is not evidence. Correct. That's all the questions I have, Connor.
All right, thank you, Mr. Pryor.
No questions, Jared.
All right, the next topic then the court will address with you, Juror 647, relates to responses you provided on your questionnaire starting on page 12. And this is on the topic of attitudes regarding the death penalty. Do you recall reading through those questions and answering those in the questionnaire?
Yes,
And are the answers you provided still true and accurate in the way you feel as you sit here today?
yes,
All right, as I previously stated, in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. So considering that, then you were posed a question about do you support or oppose the death penalty? And to summarize, you said it's more complicated than that for me. Is that a good summary of how you answered? You question marked both of those options.
Yes, because I don't think I actually have a strong opinion in, I know when I got maybe over to page 13 and just talking about that there is law and there is rule. I don't know those and I'm not familiar with it. So that is something that kind of swayed my support or oppose. I would need to have more information,
Okay.
grasp that like understanding of the process.
You stated in your questionnaire that your views on the death penalty would not prevent you from being impartial in this case and viewing the facts impartially. Do you still feel that way?
I do feel that way.
You've also stated that your views on the death penalty would not prevent you from the ability to return a guilty verdict of first-degree murder if the state proved its case beyond a reasonable doubt. Do you still feel that way?
Yep, I still feel the same way.
All right, on page 13, you did circle D out of the choices there to say what most accurately represents how you feel. You said the choice you made, not your words, but in the questionnaire. I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if called for by the facts, law, and instructions in the case. You added some additional language on that, but is that still the way you feel at this time?
Given those choices I was given, yes, that was the one that I would say would be closest to my alignment.
Okay, so to be clear, if the court did instruct you that in this particular case you were to consider it, you're telling me that would not impact your ability to return a verdict, is that correct?
Correct.
And if the state proved its case beyond a reasonable doubt, you would be able to return a guilty verdict, is that correct?
Correct.
And likewise, you would be also willing to fully follow any instructions the court gave you, even if it required you to consider the death penalty. Is that accurately how you feel?
Yes, correct.
All right, that will conclude the court's inquiry on Fordyce for this topic. I'll let the state proceed if they have any questions.
Your Honor, I don't have any additional questions.
All right, thank you, Ms. Bailey.
No questions, Your Honor. Thank you.
Okay, juror number 647, then that concludes your individual voir dire. Thank you for your candid responses today. We'll go ahead and have you return to the jury room while we go through our remaining jurors and call you back as soon as we can. Thanks for your patience. Juror number 653 will be next. All right, juror 653, thank you for returning for some additional board questioning. There's a bit of previous case knowledge you do have. In addition, there was a concern of hardship. Let me first ask you some additional questions about the potential hardship here. You did fill out on your questionnaire and you said it could be a financial hardship given 10 weeks and no paycheck. Is that still the position you're at currently?
No, that was before my employer told me that I was covered.
Okay, thank you so much for clarifying that. Given that, then, do you have any concerns about a hardship if you are required to serve in this case?
No.
All right, with that, then, let's have this board diary limited to any questions on potential bias with some case knowledge. And then we'll move on to the next topic if we get through there, beginning with the state.
Your Honor, the state doesn't have any questions as to bias or case knowledge on this juror.
Okay,
No questions, Judge.
all right. So juror number 653, then the next topic we would discuss, is it in relation to your answers about your attitudes regarding the death penalty?
Mm-hmm.
Do you recall reading through those questions and answering those questions on that topic? It starts on page 12 in the questionnaire if you want to refer to your copy.
Yeah, go ahead.
Okay, are the answers you provided in that section of the questionnaire still true and accurate?
Yes, it is.
And that's the way you feel as you sit here today?
Yes, it is.
You indicated that you would support the death penalty and say you agree it's appropriate under Idaho law. Is that correct?
If it's appropriate, yeah.
All right. And on page 13, you were given some options about what best represents how you feel. You circled D, and D says, I am generally opposed to the death penalty, but believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts law and instructions in the case. So do you believe that accurately represents your feelings about the topic?
As far as all of this choices were, that was the closest, I guess. I'm not just straight, like, all for it, and I'm not straight against it. It's just.
Okay, in this case, I will advise you that it may be necessary for you to in fact make a determination here on the topic of death penalty and make a decision in regard to the imposition of the death penalty or some other penalty. And you need to consider that as if it would be done and would be absolute and carried out in the case. So knowing that, then where you've indicated maybe some opposition to it, would you be willing to follow the court's instructions in this case, even as it relates to any instructions on the death penalty?
Correct. I would.
Okay, is there anything about your personal views or opinions or beliefs which would make you be unable to or unwilling to follow any jury instructions provided to you?
No, not at all.
Do you have a feeling that or a belief that it would be appropriate for the death penalty to be imposed in every case where a murder has been committed?
No.
Okay, so you'd be willing to consider each case independently based on a court's instruction?
Independently on the facts of the case.
All right, that will conclude the court's inquiry as it relates to this juror. Does the state have any questions for juror 653 on that issue?
We have no questions, Your Honor.
No questions, Your Honor.
Okay, thank you for returning juror 653. We'll have you go back to the jury room and we should be getting to you pretty quick here to release you for the evening. We'll next bring in juror 686. All right, welcome back, juror number 686. This is the time we have for some individual questioning. I'd note that you didn't indicate any previous knowledge of the case. So in terms of bias, I'll just inquire of the state, will the state leave any further voir dire on bias?
Your Honor, I have no questions regarding bias or hardship.
All right.
I don't either, Judge.
Okay, I've actually got one I do want to follow up on hardship, just to be clear here, juror 686. So you said the length of the trial wouldn't be a problem. You did make one comment on page 20, and you said that with the court's trial schedule of finishing each day at 3:30, it said that time would allow me to continue to fulfill work obligations. So I wanted to sort of clarify what may be happening here. Is it your proposal to us or yourself that would you believe you're going to be working full time or maintaining whatever current job you have while this trial is going for those 10 weeks?
Not full-time, part-time. I'm a resident for my clinic. And so I would either need to contact the residency board and my company and kind of let them know that I'm going to be completely off for 10 weeks or work, a few hours every day just to kind of maintain my residency position.
Okay. The reason I bring that up is I believe you may find between the time to get here, leave and listen to trial through a day, that you might be mentally exhausted and done working. So I just want to dispel any sense that maybe somebody could work full-time and do this full-time. I think it'd be very difficult. So I appreciate your response. The court raised that. Any further questions on his work obligations from the state?
I guess just briefly with that additional information, does anything about that in your mind impact your ability to sit on a jury in this matter?
No, if I'm here, I'm committed.
Thank you. I have no additional questions.
Okay.
No questions, Judge. Thank you.
All right. The next topic then we'll get to is on your attitudes regarding the death penalty. That was addressed in the questionnaire starting on page 12. Do you recall reading through those questions and answering those questions?
I do.
As you sit here today, do you think your responses are still accurate in the way you feel?
I do.
All right, let me just advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be considered as if it is absolute and will be carried out in this case. So with that in mind, I'll note you had a choice first on page 12 on the question, do you support or oppose the death penalty? You said you support the death penalty. Is that still your position here today?
It is.
You next stated you didn't think any opinion you held on that would prevent you from being an impartial juror. Is that still the way you feel?
Correct.
And do you believe you'd be able to follow all of the court's instructions relating to the death penalty if they were provided in this case?
I do.
All right. On your selections on page 13, where we gave you some options about what most accurately represents the way you feel, you selected choice D that said, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Is that the way you feel about it?
Yes.
Okay, so with that general opposition, I'll just ask you to cover this. Does that mean you're not in favor of the death penalty in every case?
So I guess to clarify, I support the death penalty as an option. I personally feel that I generally oppose it just because I feel that death might be considered an easy way out for some people. And so part of that goes along with my argument against it, which is the life imprisonment in a small cell would be, I consider, a far worse punishment than killing someone.
Okay. given all of your thoughts on this then and your responses, is it correct for me to say that you would be willing to follow any court's instructions, even if it required you to consider the death penalty on proof of evidence by the state?
Yes.
All right, that will conclude the court's voir dire on that topic for this juror 686. Does the state have any questions?
The state does not have any additional questions.
All right, thank you from the defense. Okay, juror 686, thank you for returning for individual voir dire. We're going to talk to one more juror individually, and then we'll bring you back in.
Oh, thank you.
You're welcome. Our final juror of this group will be juror 740. All right, juror 740, thank you for returning. We've got some additional individual questions for you. Do you recall filling out and completing the questionnaire last week?
Yes,
And is everything you provided in there still true and accurate as well as you remember?
yes.
Okay, counsel, there are some indications here both of a potential hardship and also a knowledge of the case we need to discuss. Let me first indicate you said, and we don't need to discuss terms, you can if you would like. You've got a medical procedure that would need to be rescheduled. You did indicate you thought that would be a hardship. If you were required to serve here for 10 weeks, let me just confirm, is it still the status, as you mentioned in here, that that procedure would have to be rescheduled?
Yes.
And how, can you just explain to me a little bit about how much of a hardship that would be, or whether you just simply think that shouldn't be rescheduled?
No, I don't think it'll be a hardship. I can just have it rescheduled until August or.
Okay, so it's an elective procedure and it's not on some critical time frame. Okay, that was my only question on that. Counsel, you can inquire further on any hardship. In addition, there is some case knowledge, starting with the state. If you'd like a question on bias, we'll begin there.
Your Honor. Juror 740, so reading over your questionnaire, it looks like you have followed this case fairly closely. Is that accurate?
Yes.
And it looks like, and I'm not gonna delve into it, but you know a lot of the facts, or at least the facts as reported by the media.
Correct.
And you're familiar with the defendant's, with his wife's case.
Correct.
And you mentioned, did you follow that trial?
Just from the news reports.
The news reports, okay. But you did keep her with it.
Yes.
And is there, you have your questionnaire with you. Would you open it to page 19? And question 10D.
Yes.
And so is it fair, and I don't want to mischaracterize what you said, but is it fair to say that you feel as though the media has portrayed this defendant as guilty?
Correct.
And you then go on to say you'd be able to put that out of your mind and render an impartial verdict.
I think I.
Okay. Thank you for your honesty. Understanding, you understand that the state has the burden of proof. Correct? And this defendant has the benefit of the presumption. He is innocent until proven guilty. And so when you say, I think I can, and there's not a wrong answer. There's nothing wrong with your answer, just to be clear. Can you understand how both the state and the defendant might be concerned that that's not an unqualified, yes, I can set it aside?
Yes.
I did want to ask another question, may relate to bias. And I don't want to go into details of it. It sounds like one of your siblings may have gotten into a little bit of trouble. Correct. Would that affect how you view law enforcement or the court system in any way?
I have a bias against how his court is handled.
Okay. Thank you for your honesty. Do you think, is it possible that that might even unintentionally seep into how you view this case?
It's possible, but I think it would seep in that innocent until proven guilty.
Okay, so on the benefit of the defense.
Yes.
Your Honor, based on Juror 740's answer, they think they can, but without that unqualified ability to state that she can render an impartial verdict, the state would move to excuse 740 for cause.
Response from the defense.
Judge, I guess given that, slightly unclear answer about whether she could or not, I'm sure she tried to do her best. I'm sure she would. I think I have to stipulate agree with this thing.
All right, there's been a motion to strike the cause 740 from the state, not opposed by the defense. The court is likewise concerned that too much knowledge and information about this case may have led to a shifting of the burden against the presumption of innocence of the defendant. Again, it's nothing personal. Everybody's certainly entitled to follow the news. Many people do, and oftentimes draw opinions based on what they've seen. In this particular case, that would make it inappropriate for you to continue on as a juror. So you have faithfully concluded your service as a juror in this case. Thank you so much for taking the time you did to come in today, as well as filling out your questionnaire last week. You will be excused for cause, and please leave your copy of your questionnaire with the bailiff on your way out.
Thank you.
Thank you. All right, Mr. Bailiff, we'll have the remaining jurors return, please.
If there's something wrong, I can hear.
Okay.
Sherry, do we have a count for the end of the day? Did we make 15? We have to get to 50.
All right.
Okay.
Thank you. Please be seated. All right, if I correctly organized my stack here, biggest number smallest, we should have returning here jurors 686, 653, 647, 631, 536, 526, and 505. Did I catch all of your numbers there? Is there anybody here that I didn't call their number? Okay.
16.
Thank you for returning then. At this time, I'm going to ask, beginning with the state here, will the state pass these remaining jurors for cause?
Yes, Your Honor, thank you.
Does the defense pass this group for cause?
Yes, sir.
Okay, thank you. I know it's been a long day for you. Ladies and gentlemen of the jury, you have been passed for cause. We'll continue to question additional groups of jurors until we reach the necessary number we need to exercise peremptory challenges. You're going to receive additional instructions through our jury commissioner, Randy Rutland, who will advise you of when you will be required to return to find out if you are selected to serve in this case. While you are waiting for that to happen, please follow the court's previous admonishment not to do anything to develop a bias in this case by investigating the case. Don't do any investigation of the case, look into the case, discuss your jury service with anyone other than to talk about potentially arranging schedules to provide for your jury service. And I'll be asking you to complete an admonishment when you return that you have followed that instruction and not investigated the case. If anybody wants to talk to you about the case, don't allow them to. And if they persist, you can report that to the court. With that in mind, then, I believe this group of jurors can be excused, awaiting further instructions on when you'll return. Anything else before we allow them to be released today from the state?
No, Your Honor, thank you.
From the defense? Okay, everyone, please rise. We'll let these jurors be excused. Thank you. Please be seated. Council, we have another group lined up for tomorrow, 9 o'clock. Given the schedule and where we went today, the good news is we did go through a lot of jurors and get some available for peremptory challenge. It took a while, and we still need to get through questionnaires to be releasing jurors that simply aren't going to be able to serve, so we don't have so many being held up. So my proposition is to do that group at 9 and then work through some questionnaires and a few other additional matters the court needs to attend to. Does the state approve of that plan going forward for tomorrow's schedule?
Yes, Your Honor. If I might inquire if the court happens to have an idea of how many groups you'd like us to have ready to do the questionnaires.
Okay, I'll probably address that as an administrative matter off the record, and we can talk about that before we leave today. From the defense, are you okay with that time, Mr. Pryor?
Yes,
Okay, we'll take up that group tomorrow then. We'll go off the record at this point, and I'll talk to counsel about preparation for jury questionnaire reviews tomorrow. That will conclude the proceedings. Thanks everyone for complying with the court's administrative order for the courtroom. We'll be in recess.
All right, everybody, that's jury selection day 1. We have 15 potential jurors, and we go until we get to 50. So I will be back bright and early in the morning for day 2, and I hope you will be here too. Yes, 15 out of 50. Thanks. Don't forget to hit the thumbs up. Everybody on X, thank y'all so much for watching with me. I really appreciate y'all over there. And I'll see you tomorrow. Bye.